today we are our first, I guess, start the process, trust the process of the fall, and we have Dr. Moore speaking today about maybe a clinical standpoint related to subpoena and court related issues.
Thank you much.
Thank you. Well, I'm Dr. Ruth Outz Moore, and I just want to tell you a little bit about who I am and how I got to this place. So I've been a clinical mental health counselor for about 26 years now, and a counselor educator for 21 years. And my area of specialty is counseling children and adolescents who've experienced abuse and trauma. So one of the things that happens when you work with abuse and trauma is there's a lot of court involvement. And what I found was early in my career that I was getting subpoenaed to court and I didn't know what I was doing. And it can be a very intimidating and daunting process. So I began getting trained and then training other professionals on how to testify in court, expert witness testimony, how to appropriately respond to a subpoena, and understanding the potential liability that goes along with court cases. So it's really a lot of counselors don't get that type of training, even in a doc program, that they don't get a whole lot of training in courtroom dynamics. So this presentation is just going to be the tip of the iceberg. And we will be doing a part 2 next month. So there will be things we might touch on today that I don't go too much in depth about, but we will get to that because we seriously could spend an entire week going over dynamics and all of that. But so I'm very excited to be here, and thank you all for being here as well. So I'm going to share my screen. Okay, and start the slideshow. Okay, so the title of this presentation is I Got a What? Understanding how to respond to a subpoena and work with clients and families with court involvement. And I did the I got a what because a lot of times when people get a subpoena, especially for the first time, they're very shocked, they're overwhelmed, and maybe feel blindsided in the fact that they had no idea that this client or family had court involvement or potentially could have court involvement, because sometimes they don't tell you that there may be a hidden agenda of bringing a child to counseling, hoping to get what they want out of court. So it can be a very shocking and daunting process. So we're going to look at today just some action steps that counselors can take upon receipt of the subpoena, some roles that counselors may serve with a family with court involvement, and the multidisciplinary team and which professionals may serve on that multidisciplinary team. So I'm going to start first with just the roles of counselors. So counselors can perform in different roles. So you've got counselors that work in agencies, you've got counselors that might work in schools. Counselors can also get trained to be a forensic evaluator, to be a custody evaluator. Counselors function as marriage and couples counselors, family counselors. They can be a parental consultant where they do psychoeducation with parents to just educate them about certain issues that children may have. They might be a court trainer. You can get trained as a counselor as a court trainer, which basically helps you work with clients who are going to court to kind of help them prepare and know what to expect when they get there. Counselors can also serve as child advocates, where a child may be involved with the court system, but they're really serving more as an advocate for the client or for the child than they are as the counselor or therapist. So with that, in knowing that counselors can function in different roles, they also can be asked or subpoenaed to be witnesses in a variety of cases. So they might be called to chancery court. So in the states of Mississippi, Tennessee, and Delaware, child custody hearings, divorce court, those types of things are handled in chancery court. In the other states, the divorces are handled in circuit court. So you might see, depending on where you live, if you get a subpoena, that it might say you're subpoenaed from the circuit court, or you're subpoenaed from the chancery court, or you're subpoenaed. And all states are different. So it's important to kind of get a feel of which courts are there in your state and how to handle that. Family and youth court, these are courts where they may handle truancy if there are allegations of abuse and family and children's services gets involved and the child is removed from the home, you may be asked to testify in family court or youth court. And it can, like I said, be called different things depending on where you are. You may also be called to serve in criminal court. This is where there's been abuse of a child, child pornography, any of those things. You might also be asked to testify on behalf of an alleged perpetrator. I had a case where I was working with a father in therapy where he had been accused of shaking the baby. Well, he admitted to shaking the baby, to the point that 3/4 of the baby's brain they referenced it as mush. So they asked me to come to court. It was criminal court, but to kind of give help the court have a better understanding of what led up to him doing what he did. So, lots of different ways that you might get involved in criminal court. Also, clients involved in litigation, like personal injury. I had a case where the individual had been in a car wreck and suffered PTSD, but when he had some internal bleeding, and then when they did the surgery, they botched the surgery, and so he was basically his abdomen was disfigured, and so they asked me to testify just to the level and depth of his PTSD and all of that. And also, there are times where you may be asked to provide the court with information, just an educator, somebody that doesn't have any interest in the case, that they'll bring you on to say, hey, could you please educate the court what is parental alienation? And I've testified in cases like that where I don't know any details about the case. I just give basically the information to the court. So I want to talk about multidisciplinary collaboration, because when you're working with families with court involvement, there are a lot of people that are involved in these cases simultaneously. So it's important to kind of know who these people are and what they do. So you're going to have contact with other professionals, and multidisciplinary collaboration can be helpful because you've got lots of people working together and they're trying to come up with a plan that can build family cohesion, that can help the child develop resilience. So multidisciplinary collaboration can be a really good thing. So who are these people? So you may have, you as the counselor, there may be a forensic custody evaluator. You may have a forensic custody evaluator. That's the person that has a very specific protocol in looking at family dynamics and parental dynamics and child-parent relationships. A guardian ad litem is like an attorney for the child. So it can be court appointed, where usually you'll see mom may have an attorney, the other parent may have an attorney, but they appoint a guardian ad litem to be the advocate for that child. There obviously is a judge involved in these cases. There can be multiple attorneys involved in these cases. Parenting coordinator, you'll see a parenting coordinator a lot when there is a high conflict divorce and a custody dispute that's getting really sticky, where you have what we call resist refuse dynamics, where a child is resisting going to the other parent's house, whether that be because of alienation or just more of an alignment with one parent. But the parenting coordinator will come in and try to assist with building those relationships and maybe supervising visitation or outlining what's to be expected with visitation. And reconciliation therapist is somebody that, like a parenting coordinator, but they can come on board when there has been estrangement, that maybe this parent hasn't seen this child in a year because of alienation, that the reconciliation therapist will be a part of that team to figure out how do we help this visitation occur, but not be traumatizing to the child, but also just helping them rebuild that relationship. So there are problems with multiple roles, though. So a lot of times what you'll find in these cases is that counselors feel sucked into a different role. So if a counselor is functioning as the child's therapist, let's say, but then one parent is saying, well, why don't you ask this child this, or why don't you ask this child this, or an attorney is putting pressure on the counselor to ask certain questions, which really pushes you more into a forensic role, like a forensic evaluator. And that's not your role in the case. So when counselors start to blur those boundaries and function in multiple roles, ethical dilemmas really will arise, and the client will develop issues of trust and safety, or easily could. Clients trust the counselor to be their ally and the environment to be a safe place. So when we think about it, that's what therapy is supposed to be, the safe place. But when we start getting into multiple roles, and when we start getting multiple professionals who are involved, it's kind of like that expression, too many cooks can spoil the broth, that we've got a lot of people, and if we're not working together and the boundaries are being blurred with everyone, it really can contaminate the therapeutic relationship. So counselors, it's not uncommon for counselors to experience confusion about their role. And that's why it's important to be very clear in what your role is and articulate that role to your clients in the beginning of counseling and maintain that role. So I get calls a lot of times where, so let's say I'm working with a child in therapy where there have been allegations of abuse, and I might get a call from a social worker from Family and Children's Services where they'll say, hey, we didn't get a disclosure from the child. So if the mom said she disclosed, we didn't get a disclosure, but if anyone can get the child to disclose, it's you. So we've referred her to you so that you can get this child to disclose. No. I'm not the forensic interviewer. You've had a forensic interview done. The child did not disclose. I'm here to do therapy. I can help this child work through their anxiety. I can help the child, give the child a safe space to work through whatever the child needs to work through. I'm not going to do a forensic interview with this child because I'm not the forensic interviewer. But you have to be very clear in those boundaries. Now, does that mean that that child won't come into the playroom and make a disclosure of abuse? Absolutely, the child could, but that's not my agenda in going in there. That's not my role. So attorneys may try to pull you into a different role because attorneys want to win. That's what it's about. They don't care what your role is. And if they can get you to perform in a role that they want you to perform in, it's a win-win for them. So be very cautious of that. Be certain that all the parties involved are clear as to what their role is, so that the attorney knows, I'm not the forensic evaluator. I'm not the parenting coordinator. I'm the child's therapist. I'm not going to coordinate the visitation here. That's not my role. And communicate that regularly. You may feel like you're a broken record. How many times do I say this? My code of ethics says avoid changing roles. And be clear that the client understands that, or if you're working with the child and the child is your client, that if the parent is saying, well, why can't you, I don't understand why you can't go in and ask her this, or why can't you ask her that? It's like, again, remember I told you, and we went over informed consent, this is my role, and this is what I'm going to do here. So clients are often unaware of consequences when making disclosures, that whether we're talking about children or whether we're talking about adolescents or whether we're talking about adult clients, that if they make disclosures to you, that they're often unaware of what is going to happen with that. Let me say they shouldn't be, because we're going to talk about informed consent, and with the informed consent process, it should be very clear that what the consequences will be of making disclosures. But a lot of times counselors have an informed consent document. They give it to the client with a stack of papers, and the client just signs everything. How many of you really read the privacy practices when you go to your doctor's office, or the HIPAA forms, and that we just kind of look, okay, sign it. And so as the counselor, we've got to make sure that they understand what they're signing, particularly as it relates to informed consent. So as I said, sharing information and records can contaminate the therapeutic process or therapeutic relationships. So you really want to assign roles to other court professionals when possible. For example, if let's say I'm working with a mother who comes in and says, hey, I don't know what to do. My child doesn't want to go see her father. She's saying that he yells at her and that he threw a chair at her. The mother is my client. I would recommend that the child get involved in counseling if child's having these kinds of challenges. Let's say this ends up being a case with court involvement, that then it's okay to give recommendations, but specific to your client, and letting your client also know that what your role is, and that you can't overstep that boundary. But it is, other cases might be if I'm working with a child, and let's say the parents are both, I can talk to the parents about the child and how to respond to the child's underlying needs, but I can't counsel mom if the child's my client. I can't counsel dad. Let's say dad is having lots of anger management issues because he's frustrated with the child. I can suggest that dad go see a counselor, or that mom go see a counselor to work through their own personal issues, but I'm not going to try to take that on myself, and shouldn't. Oh, we got some duplicates. So the legal issues that are important to note in these cases is that it's important to know your mandated reporting laws in your state, because they can differ. Being a mandated reporter and a child advocate are different, but know that as counselors, we are mandated reporters. And so we do have to make those reports. And it is any suspicion of abuse. It's not whether I believe it happened or not. So let's say you're working with a family where there's a high conflict divorce, and that one parent is bad mouthing the other parent to the child, and the child doesn't want to go to the other parent's home and that type of thing. And then the child says, well, I don't want to go to my other parent's home because she's abusing me. Okay. Even if you don't at all believe there's any truth to it at all, you still have to make that report, because it's suspicion. If a child makes that disclosure, you still have to report that. That's a whole nother workshop in and of itself. So we might talk more about that in part 2. Document everything. Document. If you don't document it, it didn't happen. And when I said it before, cases with court involvement have such high liability that you really need to be sure that you dot your I's and cross your T's. Mishandling information can contaminate the case. And I said that before about role confusion, but also just not making a report when you should, that it can really contaminate the case. And so if somebody, and when you think about that with all of the other court professionals involved, the multidisciplinary team, it's not just you mishandling information. Law enforcement mishandles information. Family and Children's Services may mishandle information, but if you're working with that case and somebody mishandles information, it still can contaminate the case and make your role very difficult. You can't fix what other people do, and you can't control what the other professionals do, but you can know that you have done all that you were supposed to do, and that you've done it correctly and ethically by staying in your lane and making sure that you document. So other legal issues, there may be a duty to warn. You may have somebody that's threatening to do harm to someone else. There may be a duty to protect. You may have a client that's suicidal, or expressing an intent to commit suicide. Another thing that's important to think about is age of consent for treatment in your state. So that differs. Some states it's 18, that you have to be 18 to consent for treatment. Some states it's 16. And so then it gets sticky about, okay, so what are the rights to confidentiality? If the child can consent at 16 to treatment, do the parents have a right to be involved in that treatment? Do they have a right to that information? And again, this is a whole nother workshop in and of itself, but that's where it's really important to one, be familiar with that, but have an attorney on speed dial that you can pick their brain. I had an attorney, he passed away, friend, but he would pick my brain about cases. Let me ask you something. And I would call him and pick his brain. Let me ask you something, because I'm not an attorney and laws change and get updated. And I can't keep up with every law that changes in the state where attorneys do, especially when they're practicing family law and those types of things. So it is important to know that. The other thing is the age of consent for sexual activity. Some cases it might be 16, some cases it might be 18, but that's the other thing when you're looking at mandated reporting, is that if a 16-year-old child had what the 16-year-old called consensual sex with a 30-year-old, is that considered abuse? What do your state laws say about that? If a 14-year-old had sex with a 30-year-old, even if the 14-year-old called it consent, if the state would say no, depending on the state, or they might consider it to be what they call statutory rape and those types of things. So it's important to know that the age of consent for sexual activity. So ethical issues, I'm not going to go through every, let me just begin by saying, read your code of ethics and read it regularly. When you get a case that you feel like, oh man, this is like, oh, this case is overwhelming, read your code of ethics. Ask yourself, what is overwhelming about this for me? And then, what does the code of ethics say about this? Also, have your own ethical decision-making model that you use. How do I make ethical decisions based on the model that is the best fit for me? So these are just some codes that Dr. Rush Wilson, I'm assuming, will make the PowerPoint available to the participants as well. Okay, so this is a good reference for you. These are some codes that are important when you're working with cases with court involvement. Client welfare, informed consent. I touched on that. We won't go a whole lot into informed consent, except what I've said before is just to make sure that you have that your informed consent is very clear, particularly if you're working with court-ordered families. And I say that if you work with children, you will likely be, even if you say, I'm not doing court, it's like, yeah, you want to bet, that you very likely will. So whether you plan on working with court-ordered or court involved families, I would still say have something in there. If you're working at an agency, if that's not in their informed consent, I had a situation recently with a student where she was working at an agency, and they really did a great, she was subpoenaed. They did a great job of protecting her and giving her information and answering questions. They even had an attorney that she was able to meet with. But there wasn't anything in their informed consent about fees, like how do you pay for court, who pays for court, those types of things. So I think it was eye-opening for this person to realize that, wow, there are a lot there's a lot of information that really needs to be included in that informed consent form. So that might be something when you sign on with your agency that you ask, what are our policies, what are our procedures, and all of that. Where's the informed consent form, and look at that. Clients served by others. This is where we're getting into multidisciplinary collaboration. What does that look like? Obviously, avoiding harm and imposing values, working with multiple clients. So how do you maintain that role? A lot of good information in there. Section B talks about confidentiality and privacy, respecting the client's rights, the exceptions to confidentiality, and understand your state laws trump code of ethics. Hopefully there's not too much of a discrepancy, but just in knowing what are the limitations or the exceptions to confidentiality. Information shared by others. This is an important one because when there's court involvement, you may be asked to share information, and then it's important to know what you should share, how much you should share. Is it necessary for me to share this information? Couples and family counseling, that's where it gets sticky as well, and let's say you're working with a couple and the couple is your client. So in couples counseling, the couple is your client, not one or the other. And then let's say the couple splits, and then somebody wants you to come in and testify on their behalf, or somebody then wants you to become their individual counselor when you've been the couples counselor, and that's really not a good idea. So a lot of things there. Clients lacking capacity to give consent, and then of course records and documentation. So we're going to talk more about records and documentation in part 2 of the presentation, but it is important to note that there's a lot of really good information in the Code of Ethics about how to handle these specific issues. Consultations on ethical obligations, that there's, like I said, great information there of just knowing when to consult and with whom to consult, and what your ethical obligation is to consult. And those, again, will be things that you document along the way. So if there's anything that as you're looking at your ethical decision-making model, and as you're looking at, okay, why am I having this reaction, or what is my biggest fear in this case? And as you're looking through the Code of Ethics, use that as your tool to, okay, I did X, Y, and Z. I spoke to my licensure board to make sure I was doing everything I'm supposed to do, and document that you spoke to your licensure board. Reporting to third parties. What does that look like if you're asked to submit a report to the court? What should be included in that? All of those things. So responding to a subpoena. Fun stuff. So first of all, if you're a student, you want to notify your site supervisor and your university supervisor immediately. That's what you want to do. Before you say anything to anybody, you want to notify your supervisor, your site supervisor, and your university supervisor. I had a situation at another university. I was not involved with this particular intern. I was not the university supervisor. They brought me in after the fact to serve as a mentor to the student after there was a big issue that happened. But what happened was that the student was working as an intern at an agency, and she was working with a mother that I believe the mother was trying to get her children back that had been removed from the home. And she got a subpoena. Well, she went to her site supervisor and said, hey, I got this subpoena. And the site supervisor said, oh, just stick it in her chart. You don't have to go to court. You're just an intern. So she got served again. And here's the subpoena. And she went to the site supervisor and said, hey, she said, file it in the chart. You're just an intern. You don't have to go to court. So this happened a couple of times. I'm not sure exactly how this happened, but I think the sheriff's department obviously got involved, and somehow it became a big mess. And the issue was that the student had not notified the university supervisor. Now, granted, the site supervisor gave her bad information, did not guide her appropriately, but that's where you have a double layer of protection that the university supervisor, had she notified them, would have said absolutely, and that university supervisor could have intervened. So make sure that you notify your site supervisor and your university supervisor immediately. If you're not licensed and you're receiving supervision, notify your supervisor. So if you're still working on those hours for licensure and you're under somebody else's supervision, then you need to let them know, because your supervisors are also at risk for vicarious liability. So if we're supervising someone and the supervisee doesn't respond appropriately, then that's on our license as well. So that's one of the things you want to do. I would encourage you in supervision. I always ask my supervisees, does anyone have any cases with court involvement? And I always get a no. And then I'll say, does anyone have any cases that could potentially have court involvement? And they pause. And I say, I want you to really think about that. Think about the cases that you're working with right now. And then some of them are like, oh, well, I do have this one. And so I try to help them process and to begin to think about, how could this end up in court? And if this ends up in court, are you doing everything right now that you need to be to hopefully stay out of court, but to document those things along the way? Be familiar with your agency's policies regarding responding to a subpoena. Different agencies have different procedures that maybe you're supposed to notify the agency director, but know what those policies are as well. Consultation can be helpful even for seasoned counselors. I have been doing, like I said, clinical mental health counseling for 26 years, I think. And when I have cases with court involvement, I have colleagues that I still consult with. I don't breach confidentiality, but I can give some basic details to say, hey, this is what I've done. Is there anything else you would do in this situation? And then I document that I've consulted and what was discussed in that consultation session. So not breaching confidentiality, like I said, but just making sure that you consult. It's a different set of eyes, a different set of ears, to maybe help you look at things from a different perspective. And legal consultation with your own attorney can be helpful. I mentioned previously that I had an attorney friend that was on speed dial, but it really can be helpful when you need clarification. And what if let's say I had a case where it was couples counseling, but one of the members of the couple said that the husband was looking at child pornography. And so it's like, okay, let me call the attorney and make sure like I'm doing what I'm supposed to be doing. What do the state laws say and things like that. So just legal consultation can be helpful. Also, I have had I've had an attorney go with me to court many times, especially when there's some of the really, really nasty cases or whatever, or if I was trying to get a subpoena quashed, and we'll talk about what that means, but it is okay to bring your own attorney. So when you get the subpoena, you want to first be aware of who subpoenaed you and their relationship to the client. So is this the mother's attorney that subpoenaed you? Is this the father's attorney? Are you working with an adult client and their client subpoenaed you, but you want to know who it came from? And be aware of what they're requesting. So attorneys are tricky. I mean, they're a little, they can have their own, like I said, agenda. So maybe what they're requesting is just records, that they're subpoenaing the records. Maybe they're not asking for your personal presence, or maybe they want you to be present, but they didn't specify the records. So, and is this for a court appearance or is this for a deposition? Because they're different things. So you want to discuss with your client the limits to confidentiality in court cases, that you don't want to go to court and then you get asked questions, you share information, and they're like, well, I didn't know you were going to say that. Well, yes, you did, because we talked about it. Being subpoenaed to court does not mean that the records have been subpoenaed. So I don't like my records to be subpoenaed. I don't, because most of the time they don't read them all. I mean, you give them this, they really want this big stack of records to go through. And we'll talk a little bit more about that with reports. Sometimes you can just write a report and give them the information that they need. But what I've had happen before in cases where let's say I'm working with a child and somebody subpoenas the records and I hand over the records, then the attorneys read the records, the attorneys share that information with the parents, and then the parents now know what the child's disclosed and what the child is doing in the playroom. I had a situation where it was a high conflict. Well, they were divorced, but there was such animosity between the parents. So it was father and stepmother and mother and stepfather, and there was such tension or conflict between them, to the point that the police had to get involved many times. And in this case, the child was coming in the playroom and he was reenacting a lot of those conflicts. So we'd have Barbie and Ken, and they'd all, start fighting. And but when that information about his playthings were documented in the record, the parents all of a sudden started knowing about that information. So then one of the parents coached the child into coming into the playroom and making, and told him what he needed to reenact in the playroom. So I do everything I can to try to avoid handing over records, but if they subpoena the records and they will not take a written report in place of those records, then you have to send them, but just be aware of that. Upon receipt of the subpoena, notify your client, that, hey, I've been subpoenaed to court over this matter, and this is what, and then obtain a written release to contact the attorney. So let's say the guy had a case where I was working with a mother, and she ended up going through a divorce, and they were fighting over custody of the child. The mother had a history of suicidal ideation and severe depression as an adolescent, and she was probably in her 20s. So it hadn't been that long ago. She also had a history of non-suicidal self-injury where she was cutting. So he was trying to say that she was an unfit mother. And somehow they found out that she was seeing me, and I think the father's attorney subpoenaed me. So I, notified her, and then we discussed whether or not, obviously I would want to speak to the other attorney to find out what this is about, and obviously try to keep me from having to appear in court. But that is just notify your client so that they are aware. So again, once you've gotten subpoenaed, you want to keep a clear picture of what your role has been throughout the case. So for example, if you're the client's mental health counselor, do not answer questions that should be addressed by the forensic interviewer. And we'll talk in part 2 more about what to say when you're actually testifying in court. But you just want to be clear. Should I answer this question, or should I? Because let's say you get subpoenaed and you contact the attorney, and the attorney says, well, yeah, we want you to come to court, and we want you to say, yeah, that this, she's disclosed to you that there was sexual abuse. We want you to come to court and be our smoking gun and say that this happened. And it's like, well, that's not really what my role is, and that's not what my testimony will be. And sometimes it's an attorney's attempt to make the counselor appear unethical, that they really are trying. It's a trap, an attorney trap. But sometimes attorneys don't understand our code of ethics, and that they just want what they want. It's like that little baby in the candy store. They want that candy. They just want you, they need you to say this. So there are many attorneys that don't want you to say or do anything that's unethical. They just might not understand that what they're asking you to do is not ethical. So you never want to give opinions about someone you have never met or never evaluated. And meeting with a parent is not an evaluation. So I say this even though we're not talking about testimony in this workshop, but it doesn't mean that once you get subpoenaed that there won't be conversations that you might have with those members of the multidisciplinary team. So let's say the guardian ad litem contacts you and says, hey, you've been subpoenaed to court, blah, blah, blah. Hey, this child disclosed allegations of sexual abuse. Do you think this happened? Again, you're not going to make those kinds of statements. You weren't there. All you can say is what the child disclosed to you. You can say things like, well, the child has named no other perpetrators. The child's disclosure appeared to be credible, but you're not, I can't say whether this happened or not. I was not there. So you never want to give an opinion about someone that you haven't met, but also meeting with someone is not an evaluation. So just because I'm working with this child and I met with this parent 6 times to talk about how to handle these issues at home, or this parent 5 times to discuss how to handle these issues, I still can't give an opinion about either parent because I did not evaluate them. And if they tried to pull me into that, yeah, but you've met with mom, you've met with dad, you've met with them. Why can't you? Because that's not my role in the case, and I did not conduct an evaluation. If you feel as though that an evaluation needs to be conducted, then I can give you a name to refer the parents to that for an evaluation, but that's not going to be me. So if you must appear in court, do they expect a written report? I don't offer anything unless they ask me. If they subpoena me to show up in court, I show up. I don't bring anything with me. Because any notes that you bring with you, they can ask to see. We'll talk more in the second part 2 about what types of things they might ask you and what you can do to take notes so that they make sense to you and maybe not to them. But sometimes a written report can be submitted in lieu of a personal court appearance. They really just want to know what you're going to say or what your thoughts are. So there are ways to submit a report sometimes instead of going to court. Written reports can be helpful because both parties know the counselor's position prior to hearing. I've had a lot of attorneys decide they don't need me in court once they read my report and know what I'm going to say and what I'm not going to say. That it's like, okay, her testimony might be harmful to our case. And again, I'm not going to say anything that's intentionally harmful, but when you think about it being about winning the case for the attorneys, that they're like, maybe we don't want her testimony after all. We'll talk more about report writing, I said in part 2, but just be very cautious when writing reports and making recommendations, and also be very cautious about what you say when you're consulting with other members of the multidisciplinary team, and make sure you document that as well. I've found that in my experience, there are a lot of attorneys that don't, it's interesting to me, that don't document as well as they should. And so like the client might get a bill that says multiple emails, like no dates of emails or anything like that, where we're way more specific. But I think that works in our favor as counselors, because we can say, no, I talked to the guardian ad litem on January 24th at 6:45 p.m. And this is what was discussed and this is what was said, as opposed to the guardian ad litem who might not have documented and said, oh yeah, I talked to her. I didn't, and not have that information. So it really does protect you. When we're submitting a written report, review the report with the client before submitting it and give them the opportunity to ask questions. That is very important, just so that they know and understand you're transparent with, this is what I'm saying in the report. Give the client the opportunity to ask questions. I had a situation where I was submitting a report on behalf of the child. I showed the report to the mother. And when I was doing the intake, I actually I had misheard something. It was like a timeline. I thought this happened before this, but it didn't. So then you can't edit your report, but I made an addendum to the report that just said that in my intake, I documented this, but that the mother has informed me that I misheard that the time frame was off, that this was the thing, and you just include that. But I always say this because about review the client with the client before submitting it. Review it yourself first, and for typos, spelling, all of that, that this is affects how they perceive you. I never will forget that I had a guardian ad litem that sent me a report that she had written about this child. And when it got to like the last two paragraphs of the report, there was another child's name and another child's information about the child's case. So the attorney had copied and pasted information from one child's report. They were not related out separate cases, but had forgotten to delete that. So it had first and last names of the child, parents, and other information. That's not, I don't even have words. It's not good. So that created a lot of problems. And remember how I said earlier that mishandling information can contaminate the case? That was just the beginning of many problems with that. And even though I didn't do it, it was the parents were up in arms. Like then they didn't trust, obviously, the guardian ad litem. How do we even know that you know who our child is when you've got other children's information in our child's report? If you're not submitting a written report, inform the client of what you are likely to be asked and what your testimony and recommendations will be. Because a lot of times parents go in and think, oh, if you're working with a child, that you're going to, oh, well, my attorney's going to ask you this, 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 and this. And then problem solved. We get the answers that we want. But I also will say, yes, I recognize your attorney is going to ask me this, 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 and this. But I need you to understand the other parent's attorney is going to likely ask me this. A case example was where a mother was accused of coaching the child and coercing the child to give a disclosure of sexual abuse on camera, and she followed the child around to the point that when the therapist saw it, she reported the mother because she felt that was abuse because it went on all day. In therapy, the child had disclosed had made a disclosure to me about sexual abuse, but it was also the exact same disclosure that the mother had made. So again, I'm not here to decide true or untrue. I'm just here to work with the child in therapy. But the mother was really pushing for me to go to court and to be the smoking gun where it's, and that, she's going to ask you this and you're going to say yes, because she did disclose to you and she disclosed this. And I said, yes, but I need you also to understand this is what they're going to ask me. Have you seen the video? Are you aware that she followed the child around with the camera? Do you feel that is appropriate? And I said, I'm going to have to say no to that. Isn't it possible that this child could be afraid of her father, not because he's done anything, but because the mother has? And I'm going to have to say yes to that. And she's like, but that's not true. And I said, they're asking me, is this a possibility? And yes, this is a possibility. And that's how I'm going to have to answer that question. And that's when they decided they didn't need me to be in court but I prepared them for that it's not just about one side, it's about what the other side is going to ask you as well. You want to give them the opportunity to ask questions and document that you discussed this with the client. Going back to depositions, I should put that slide back when we talked about depositions, but depositions are different from a court appearance. So in depositions, they can ask you anything, and depositions are much longer than a court. If you testify in court, you might be on the stand for 30 minutes. I think I've been on the stand, I think an hour and a half is probably the longest I've been on the witness stand. But depositions, I think my longest was 8 hours that I was there answering questions for 8 hours. They can ask you anything. How do you know the attorney? Have you ever been to his house? I got asked if I'd ever been to lunch with the other attorney before. They can ask you anything that they want to. So they can be asked to bring all references and information used to make recommendations, as well as the client's file. So only bring what's subpoenaed. So I was subpoenaed for a deposition once, and they asked for any and all books, journal articles. The list went on. I mean, it was a team of attorneys. This parent had a team of attorneys, and so I show up with boxes and boxes of stuff. And I was like, y'all want me to bring them? But it is intimidating. But I think that the more you're aware of these dynamics, it can be less intimidating by just knowing that you know that you know how to clearly read and understand what's in the subpoena and not bring anything that's not. I can't tell you how many cases that have gone to court to testify and they're like, did you bring the record? I said, no. Why didn't you bring the record? Because you didn't subpoena the record. You didn't ask me to bring the record. And I don't bring it. I don't, because then again, they can take that record and anything that you bring can become part of evidence. And I don't want that. Be sure to document all contact with any of the parties involved in the case. Keep accurate records, especially when there are disclosures of abuse. We'll talk more about documentation in the next session, but using seems and appears instead of absolute statements. If you're writing information, include where you got the information, who you talked to, who you weren't able to talk to, who you tried to talk to. You know, I reached out to the guardian ad litem 6 times and never got a return phone call. So I guess this is our time where we have, okay. I don't know. Oh, I'm sorry. Okay, so this is our time for questions.
I have a question for you. So first of all, thank you for doing this. Second, with the GAL or with the guardian ad litem, if they ask, when they subpoena the record, do you give it to them? Do you usually try to submit a report with them as well?
So yes, so if they ask me for the report, I usually will explain to them why I will do a report if they need a report. But if they ask me for the records, I will say, do we really have to do it this way? So I will definitely, if they ask me to submit a report, I will, but I will talk to all the parties involved. And, but yes, and it really depends also what's in the court. Like if I'm court ordered to be the child's counselor, it's a little bit different as opposed to if I'm involved, just as involved as the child's therapist, that I would need to have releases signed to the guardian ad litem. So if it's court ordered, they're usually very specific about, and you're going to need to submit a report to the guardian ad litem.
Okay. And then I actually have a list of questions. I'll just ask one more though for now. The other one is a quick one. With release of information with the guardian ad litem, do you have the client's parents or whomever sign a release in your office too, or do you only go with the one that comes to you from the GAL?
I always have them sign a release, and even if it's in the court order, I still have the parents sign. If I'm court ordered and it says you've got to submit this information, I still have the parents sign a release. I don't have to because it's in the court order, but I just feel more comfortable doing that so that there's not any, well, I didn't know this was in the court order. It's like, okay, well, we talked about it, and I will make it clear, hey, it's already in the court order that I have to submit a report, but I'd like to just include in the file that you are aware that that's in the court order and that I will be releasing this information. It's just a double layer of protection.
The last point I'll make, then I'll turn it over. You said you use seems and appears. Do you also do client reported?
Yes. Okay. Client reported, client disclosed, client seems to have fear. The seems and appears are really just in saying, that I'm not saying the child is afraid of the parent, the child seems afraid, or the child has expressed feeling fear towards the parent. But I'm not going to say the child is afraid of her father, because it's just a little bit of risky language. And what I've realized over the years, and I've testified in countless cases, well over 100 cases in different courts, whether criminal, chancery, circuit, youth court, family court, and criminal, all of that. But what I found is that your words are very important, and y'all have seen shows on TV that where they pick apart your words, of just being very cautious about how might they use this against me, how might they come back at me with this. So, and that comes from experience, it really does, and from attending workshops like this, of just saying, okay, how can I respond competently and confidently, and not take years off of my life stressing over this case. I've done that too, though. I have done that. Any other questions?
Yeah, I have a question.
Uh-huh.
What is the difference between duty to warn and duty to protect?
Duty protect is more along the of if a client is suicidal, that's you've got the duties to protect that client, and duty to warn is to warn the other person that the client is threatening. So homicide versus suicide.
Okay, thank you.
I have a question. You mentioned about doing addendums to indicate the corrections that are needing to be made or corrected from the initial evaluation. If you're creating it, you're reading it, and then your client is reading it to confirm that what is documented is accurate, what would the addendum be for then? If both parties are in agreement that this is the accurate information?
Well, so if I write a report and then I say, okay, here's the report that I'm going to be submitting, whether to the guardian ad litem or to the attorneys or whatever, and so I show it to the client, and the client says, oh no, you've got in the report that this happened in 2016. This happened in 2016, but this was actually 2018. Then you can't modify a report once it's been completed. So because you don't want to be perceived as like the client told you what to put in the report, but you can do the addendum that says in this report, in my intake, this is what I heard. However, the client has informed me that this was what happened. Now, does that mean I don't know? I mean, this is how I heard it. This is how I documented it. That's what I wrote down. But I also know when you're doing that intake and you're taking information, you're writing down a lot of stuff. And when I go back sometimes and read my handwriting, I'm like, what does that say? So it could be that I really misheard it. And this doesn't happen very often, but it can. But if I misheard it, then I've documented that this is the correction. If the client is saying, is not being honest about it, that's not up for me to decide. This is what I can tell you. Now, they could pick that apart and say, first she said this and now she's saying this. And, they can say that, say, well, that's a possibility, but it also could be that I misheard that information. Does that make sense?
Yes, it does. Thank you.
Okay. Yeah, you can't modify the record once it's been there. So even if let's say I had wrote a progress note and the client said, hey, we also talked about this in the session, but you didn't put that in the note. It's like, well, I don't put everything that's said in the session in the note, but if the client requests that be documented, then I can do an addendum to the note, but I'm not going to modify the note. And again, that's been very rare. I did have, I can think of maybe really only one or two where it's just been something where a detail or a date got off.
Thank you for that.
Oh, you're welcome. Thank you for the question.
I would like to make a question, but first I would like to say that as somebody that bought an apartment in Copacabana Beach by crushing expert witnesses, I am baffled and I'm shocked with this, of how much and how well you understand the legal system. And this presentation is priceless. It's priceless.
Oh, thank you.
I am sorry for my classmates that are not here right now because they will have to learn it the hard way.
Yes. Denise is was a criminal defense attorney.
A criminal attorney, yeah, for more than 30 years, and a law professor, and gets worse. I'm also a criminal psychologist, and I work in the anti-terrorism task for 3 countries. And when I started studying counseling, my biggest dilemma was, how am I gonna, join my whole previous life with this counseling task? Until I was contacted by the FBI here when there was a shooting here at Oregon District in Dayton. And they were surprised because the shooter was in counseling. And they were very surprised that the counselor could not catch it, that he was a danger to the community. So my question would be, do you see this intersection between criminology and counseling in any way?
Oh, absolutely. Absolutely. For what if you're looking at now with school shootings and things like that, and, even with the I can't think of the name of the family, but the one where the parents are actually being charged as well with the, I mean, I think absolutely that, I mean, if you look at that case, the school counselors allowed him to return to the classroom and all of that, that there's, I think there's a lot of things that could have been done differently, but certainly with criminology and a counseling degree, that would be
Great.
a great blend. I have a colleague, and we actually just presented virtually yesterday, but she's an attorney and then has a PhD in counselor education as well. So it's worked well for her. She's been a guardian ad litem for 30 years or more, but then also now can educate, and we do a lot of trainings together of just understanding those family dynamics and things like that. And actually, I think she got out of practicing law because she felt that a lot of times it was about winning in the courts, and that really nobody wins. There is no, you just paid $70,000 in attorney's fees. Did you really win? What did you win?
Yeah,
And we've got a child that has been impacted by the court system. What did the child really win? I did want to make you aware there is an organization called the Association of Family and Conciliation Courts, AFCC. It is a multidisciplinary organization that consists of judges, attorneys, psychologists, counselors, social workers, parenting coordinators, all of that. But so I'm a member of that, and actually presenting it at their conference in November. But they have, it's really, to me, been a great fit. So if you're interested in doing court work, or think that you might work with populations that will have court involvement, if you want to work with abuse and trauma, chances are you'll end up there, especially with children, that it's a great division to join. Lots of great trainings. They have a journal, but they have a couple conferences a year, regional, and then they have the annual conference. But it's been very interesting to me to hear what court experiences are like from other people's perspectives. Like I once attended a session, and it was with a judge and an attorney, and they were talking about the stress associated with high conflict divorce and clients. And I thought, I never thought that a judge would be stressed. I think about the judge but the judges talk about their stress around it, or how to handle certain things. And so it's been very interesting to hear what the other perspectives are from the other court professionals. And I think it's helped me in my multidisciplinary collaboration in better understanding those roles, and how I can maintain my role and help them, that we all can stay in our own lanes and not do harm. And the benefit and the purpose of that organization is to keep families out of court and to help them hopefully resolve conflicts more amicably, to prevent children and families from being harmed by court dynamics. So it's really a neat organization if y'all are interested.
No, thank you. That's why attorneys hate family law in juvenile cases. Attorneys like murder cases. Because it's much easier, less emotional, and less stressful. Nobody believes me when I say that, but family court can be really, really difficult. Thank you so much for the suggestion.
Thank you.
Look into it.
And thank all of you for being here for this hour. We will have a part 2 next month, and we'll send out the announcements for that. So enjoy your Saturday. And again, thank you all for coming.
Thank you very much.
Thank you all for coming.
Thank you.
I didn't realize I had my camera off the whole time, but I know we have to go because I heard you say you have to go to the gym. I have a quick question for you. You mentioned in your presentation, you talked a lot about how you said that you talked about an intern having an issue, and how they also can go to their university supervisor that could have handled that better. I was about to say, did the university supervisor then just always go back to the school policies as a background check, or is it something else additionally that university supervisors should be doing?
Well, I think the university supervisor for me, I always ask, like I said, but the university supervisor, had that happened, could have just made sure that they reached out to the site supervisor to say, okay, this, my intern has gotten this subpoena, and she was saying that you had said she didn't need to go, but you have to respond to a subpoena. And so it maybe would have been an opportunity for, and I don't know the specifics about the site supervisor, what her level of experience was or anything like that, but it might have been a moment where the university supervisor could have educated the site supervisor, and maybe even if there was somebody above her, of just ensuring that that was addressed, because it was they were about to arrest the student for failing to respond to a subpoena. Yeah.
Okay. Well, you put that bug in my ear. So now, as a university supervisor, it's like, now I just want to make sure. I was like reading over the sites, and I was like, I'm gonna just ask everybody now, because most of my students work with teens. So I just
Yeah.
with
Yeah. We and it gets and that's why it's really important to. This was at a different university, and so I don't know exactly what questions the university supervisor was asking in supervision. But again, that's where documentation on the supervisor's part is important as well, of asking those right questions. But I spend a lot of time in supervision on the front end, getting students to understand that they bring your questions to supervision. Don't hold them in, that like it, and it can get sticky. I had one student where there was a case where the person was, one of the clients was court ordered, but didn't come to the therapy session. I think it was on parole or something, but he was court ordered and didn't come. And then it was like, she was confused about what should happen, what didn't happen. But it was one where I stepped in and talked to the site supervisor to figure out, was this something that needed to be reported, and what the state law said around that. So it's really just that, keeping that open communication. You get out of supervision what you put into it, so ask those questions, and really think about, when you're conceptualizing cases, think about like, well, what might happen, what might happen if dad has never been a part of this child's life and all of a sudden comes back and wants to be a child. Could that potentially have court involvement, and how would I handle that?
Okay, thank you.
So what I'll do, Dr. Moore, is post this today, and then we'll make sure that we give this link in the next one for people, so they can watch this before they come.
Okay. I've got a couple of things in October, but so maybe we can look at